My name is John Richardson. This is Andy Grossman, and this is essentially really video 2. It was about almost 3 years ago, I think, at this time, after a session at McGill University that Andy and I sat down and talked, or I prefer to think of it another way. I've had the privilege to interview Andrew Grossman. I am a lawyer, but I will tell you that all lawyers have people who they see as lawyers. And he definitely qualifies. I don't know of anybody, frankly, in the world, period. I'm not even sure there's a close second, with the expertise and the sort of history, the practical experience in the areas of nationality, citizenship law, et cetera, et cetera. So this is certainly a treat for me this evening. And I will tell you, although you may not realize it, that you will never have the opportunity to hear somebody with this depth of knowledge in these areas again. Interestingly, citizenship is something that is completely invisible to people until they don't have it or until it's threatened. And and then once that happens, it becomes probably the single most important thing in the world. And for reasons that the way the world is unfolding, both in the United States and in many other countries, the boring topic of citizenship has in fact sort of arrived front and center on people's radar. And particularly we're here primarily to talk about American citizenship issues, and we all know it's a very difficult time to be an American citizen living outside the United States, or you wouldn't be here tonight. So certainly some of the topics that we will be talking about will covering that. But let's begin with, so what brings you back to Montreal?
Well, I had some legal issues that had to be settled, and I am updating, I've written several articles, law review articles, including a series for the NYU Global X series that are all on the internet. And the one I'm updating now is on the law of, a bibliographic article on the law of terrorism. And I was interested in going to the border and seeing what some of the challenges are, because in the 60s, before I joined the Foreign Service, I was making the trek from Massachusetts and then later from New York to Montreal, sometimes every month. And the border was quite open then. You rarely were asked for papers. You might be asked where you were born. And things have changed quite a bit. So I went to Stansted, used to be known as Rock Island, and then the three villages combined in 1995. And they had no hospital. The nearest hospital would have been in Sherbrooke. So before the Carte Soleil, before the Quebec health insurance plan, most women went to give birth to Newport, Vermont, which means that most people, or many people, my age, are dual nationals.
All right, so just pausing on that point for a minute. Dual nationals, meaning U.S. Canadian, but the U.S. because of a U.S. place of birth.
Exactly. As I've said elsewhere, there is a presumption of alienage for people born abroad, and the reverse for anyone born in the United States.
Okay, so to be clear, if born in the United States, then that would come with a presumption of American citizenship, and one could lose that American citizenship through a relinquishing act, correct?
In those days, certainly before 1980, there were many ways, as you know, to lose American citizenship. But including voting in a foreign election at one point.
Which was the subject of the Euphorium decision in '67.
Yeah. But it would have taken someone like yourself, a specialist in expatriation law, to tell them, to give advice to them, because unfortunately, in those days, today there is very little reason to cross the border to go shopping, because unless you're going to a big box store, which would mean you had to go by car. The only reason to cross the border on foot these days would be to go to the public library, which is the Haskell Free Library, is on the border, deliberately bisected by the frontier. And there is, in fact, a special immigration exception that anybody can go from either country to the library, but you have to go back the way you came. So I went there to interview people and just get some ideas. And I found that the frontier has been militarized now. You wouldn't know it. There's no Trumpian wall, but there are cameras. There are border police in 4x4s and station wagons. And there are warning signs. But if you're a child and your pet or your rubber ball goes over the line, you might get yelled at or worse by a...
Or an electric shock.
Well, there was a case where a child wandered off and got lost, and there was a problem getting them back together again with the parents, but never mind. The point is, it's been militarized, and unlike in the days when I used to go, the American immigration inspectors and the border police mostly come from someplace else and have no investment in the neighborhood. That's a very important difference.
I would think that it adds to the dynamic hugely.
Whereas the Canadians, whom I normally talk to in French to get along with them better, I think, sometimes the job has been handed down from father to son. They are much stricter than they used to be, but I find them more congenial.
A patronage appointment.
Maybe.
Canada's well known for these things, you know.
In any case, I was there, and I have drawn my conclusions, some of which I've spoken to you about now. There is a hidden problem of people. It's an area that's got a number of characteristics. It was settled by refugees from the Revolution.
So in other words, this is quite interesting, and this is something that I had not fully appreciated until the last few years. In fact, I brought a couple, some suggested reading for those who are interested. I came across this author, retired Professor Wallace Brown. It's a book, Victorious in Defeat, The Loyalists in Canada. He's got another one here, The Good Americans, who he's referring to as the Loyalists. I've often wondered, you know, they call the victors in the American Revolution the Patriots. It seems to me that it was the Loyalists who were the least patriotic to England. It's hard to know which is which. But what I hadn't fully appreciated until, you know, the last few years, which is I think hugely significant, is how much of Canada was actually founded, settled, if you will, by refugees from the American Revolution.
Yeah, there was, it created a big affair in the courts of many states, because in many states back in those days, you could not inherit land unless you were an American citizen. So who was an American citizen if they were absent from the country at the time of the Revolution? But the other thing is, the area I was visiting was largely Protestant and largely English-speaking until fairly recently. So if you think back to the days of the Québécois de pure souche, there's a T-shirt downstairs making fun of that, you will understand that these were outsiders. And they used to have some good relationship with Derby Line, Vermont, but I couldn't see that anymore today. And that was the purpose.
Bit of a division.
But it's also a poor area. Now, Magog and Memphremagog Lake are great tourist places, and I think everybody should go there in the summer, not in the winter. But frankly, Stansted is boring unless you have some reason to go there. No hotels, no restaurants, and just the most fabulous bakery in Canada.
Well, that makes it interesting, doesn't it? You know, we talk about the U.S. place of birth, and leaving aside, you know, we have constitutional considerations, of course, and we have statutory considerations. And usually when people talk about the fact of being born in the United States creating a presumption of U.S. citizenship to be rebutted by relinquishment, usually the discussion begins with the 14th Amendment to the U.S. Constitution, which contextually, of course, came about during the end of the Civil War for obvious reasons. And you know, it says basically, if you're born in the United States and subject to the jurisdiction of the United States, you are a citizen of the United States. Now, you say, well, so people born in Vermont, all right, because they're born in Vermont are American citizens, yet they cross the border, or their parents cross the border to have been born in Vermont. Does the subject to the jurisdiction of the United States, part of the 14th Amendment, have any bearing on that issue?
Well, it's interesting because, you mentioned that, because the alt-right and a number of other nativist and anti-immigration groups have put together some interesting legal arguments to the contrary. And if under the next...
To the contrary, you mean that they would not be American citizens?
That if somebody who is a transient might not be subject to the jurisdiction thereof in the sense meant by the laws of the constitutional provision and by the tradition, well, the issue of allegiance as a proxy for citizenship is something we can discuss later. But with at least one and maybe three new conservative Supreme Court justices, I could envisage a change in the interpretation of the 14th Amendment. But I'm not a constitutional law scholar, so I can't...
Well, certainly this issue is very much on the radar, this whole question of, should the Supreme Court, and my prediction is that it will, hear the issue of whether the simple fact of birth in the United States does, under the 14th Amendment of the Constitution, give somebody constitutional citizenship. Now, the reason I say constitutional citizenship, and the reason why that is so important, is because there's a series of Supreme Court decisions that interprets the 14th Amendment in such a way that the U.S. government cannot strip people of their citizenship without their consent, which is, has been a big, there's a whole incredible history of this. By statute, of course, they could say, well, anybody born in the United States is a U.S. citizen. But without a constitutional protection, then presumably the government would be in a stronger position to expatriate people.
But understand that the 14th Amendment applies to the 50 states and the District of Columbia. The territories, Guam, Puerto Rico, Virgin Islands, and formerly the Canal Zone, those are statutory citizens, and people born abroad, statutory citizens. And whether and how the 14th Amendment applies to them, we don't know.
Perhaps the rest of it, the rest of the 14th Amendment, say equal protection,
bear in mind that, as I mentioned earlier outside this, before this started, persons born or naturalized in Puerto Rico are statutory citizens, and they're subject first to the mirror income tax. And of course, it may not matter in a world in which the estate tax starts at $5 million, but it used to be significant that they were not subject to estate duty on death for their Puerto Rican property. And there are plenty of other anomalies that might have, if McCain had been nominated or had won, or Cruz, you'd get other issues regarding citizenship and eligibility for the presidency.
Right. Were they in fact
native-born
U.S. citizens? Right?
So there are more unresolved issues, more questions of doubt. Even in the case of my own children, I have 4 children and 8 grandchildren, and most were born abroad. And I don't want to go into everything now, but there are issues of doubt as to whether some of the grandchildren are American citizens or not.
But on the issue of anybody born abroad, any person born abroad is presumed to be a non-U.S. citizen.
That is the first presumption, and in what I call 7 Fam and 9 Fam in the Foreign Affairs Manual, a Foreign Service officer, a consular officer, is authorized to give a visa to someone who is unable or unwilling to provide the evidence that he or she is in fact a U.S. citizen.
So in other words, one could have a situation. So if you're born abroad, the law, of course the law is always evolving and will continue to evolve, but I think the current law is something like this, all right, that if you're born abroad to one U.S. citizen parent, if that U.S. citizen parent meets a residential connection to the United States, then that person is entitled to U.S. citizenship.
It depends whether that parent was, if the mother was married or not.
Oh, yes, absolutely.
I encourage anybody to go to Google and type in Foreign Service Journal, Tijuana, and see a great article written by a vice consul in Tijuana on this subject.
Right, and actually I want to add to that. On November the 9th, the Supreme Court of the United States heard what probably will be the single most important citizenship case since Ephraim or Teresa's. And, you know, the issue does actually, part of the issue is the difference between somebody born to an unwed mother versus in wedlock. It's a fascinating thing. If you want to Google, I think it's Morales Lynch is the name of the case. I mean, it's absolutely fascinating. In fact, this morning, first thing I did before coming down here today was I actually listened to the tape of the oral argument before the Supreme Court. It's only an hour. That's the great thing about the Supreme Court. You don't get too much time. Well, meaning that one can actually listen to the argument. But I'll tell you, it is really interesting, okay? And some of the questions from, I think it was Justice Elena Kagan, I think do have some bearing on the issues affecting Americans abroad. So, I mean, if you're at all interested in this issue, and particularly the difference between the child born in wedlock versus the unwed mother thing, it's a fascinating decision, hot off the press, you know, et cetera. But anyway, so just to be clear, okay, because this is something that a lot of people in Canada, certainly, and other countries are concerned about, is precisely this issue of, well, you know, I'm an American citizen, I've moved to Canada, I've married, you know, children are often the result. Is that offspring, is my son or daughter automatically an American citizen? Does that person have to do anything to be treated as an American citizen? What happens if that person never goes down, ever, and registers at the U.S. consulate? What are your thoughts on that?
One could go on forever on this. It's my understanding of international law that other than at birth, adoption, or certain other relationships, marriage used to be one of them, and it's probably not anymore. Nobody can be attributed citizenship without his or her consent or the consent of a guardian. The result is, and let me point out that the State Department's view of this is more or less what I said. The IRS hasn't accepted that in its regulations. And the significance of it is whether someone can be made retroactively a citizen, as Ephraim was. You understand?
Yeah, okay, but so what's meant is, what Andy means by made a citizen retroactively is basically this. The history of expatriation in the United States has, for the most part, been a series of people doing things the U.S. government didn't like and, you know, were viewed to be of sufficient gravity to strip them of their citizenship. So in the case of Ephraim, what he was a naturalized U.S. citizen, by the way, and what he did was he had the temerity to vote in an election in, I think, Israel. Mm-hmm. Either the State Department found out about this or he was dumb enough to announce this to them. But in any case, what happened was that he was stripped of his citizenship because at that time it was written into the statute that voting into a foreign election was, now this is key, an automatic expatriating act. Okay, automatic. No option, that's it. We find out you've done that, you're no longer an American citizen. Well, Ephraim had fought long and hard for his citizenship. People born in the United States tend to not value their citizenship per se. They might be unhappy to not have it, but because they didn't fight for it and have to go through the green card process, and then they tend to not value it quite as much. So what happened was that the Supreme Court ruled that the U.S. government could not strip him of his citizenship, okay? And he wanted his citizenship back, and he, of course, regarded himself as the victor, and he was. But the effect of that was to essentially set the stage where a number of people had committed expatriating acts, had presumed they had lost their citizenship, and then what happens is a case like Aforium comes along, was confirmed by another one, and all of a sudden they find that their being stripped of citizenship was unconstitutional, and therefore,
as far as the IRS is concerned, they now were Americans again. As far as the State Department was concerned, they would have to, in effect, apply for a passport.
right. Now this is hugely significant because if you're listening carefully to what Andy is saying, what we really have are two kinds of American citizenship, right? We have citizenship for the purposes of nationality and immigration, and we have citizenship for the purposes of taxation. And this was actually written into the Internal Revenue Code, if you will, in 2004.
In a different way, but to the same effect.
Same idea, right? Really confirming that we have citizenship for nationality purposes and citizenship for tax purposes. So would you agree with this statement that one could have committed an expatriating act, drive through the border, citizenship, Canadian, are you American? No. IRS calls on the phone, citizenship, or rather, are you an American citizen? Then the answer might be?
Well, it might be yes. In fact, there is a revenue ruling that says, we will forgive your taxes for the years you thought you weren't an American citizen, as long as you never benefited from an attribute of citizenship during those years.
Right.
Implying that, well, now you're a citizen whether you like it or not. That is probably a violation of international law, and I'll give you the example. You know, everybody knows the Nuremberg laws, under which Hitler stripped the Jews outside the country of their citizenship. Well, Allied Control Council, law number 1, voided the Nuremberg laws. So, in principle, all those Jews were now German citizens again. Well, in the Grundgesetz, the German Constitution, Article 116, allows them to have it back. And in fact, I know a number of people, citizens of the United States, children of escapees, Holocaust survivors, who have gone back and taken it up. And ironically, they could do that on the basis of the tax law's discrimination against in inheritance tax if your spouse is an alien. There's no point, it's a complicated issue. But that gets around the German rule that normally dual nationality is not allowed, except in some specified instances, and one of them happens to be if there's an economic advantage to having it. Right. So, but my point is that they didn't force the citizenship back on the Germans because they couldn't. And neither could the State Department force somebody. Now, there are probably hundreds of thousands, maybe millions of cases of doubtful citizenship. Because proving, as the Tijuana Vice Consul article points out, proving the fact that an unwed mother spent 365 uninterrupted days in the United States, if, for example, she lived at the border and was constantly going back and forth to Canada or to Mexico, it's probably up to the American consul, if the child is under 5, to decide what she or he thinks to accept the decision.
You mean on the question? In other words, the State Department makes the decision whether there was uninterrupted residence in the United States for a year.
If the child is over 5, the case, as I understand it, the case always goes back to the State Department. But certainly in the case of some of my grandchildren, the vice consul makes a judgment based on the facts as proven or believed. And what if there's a mistake as to the facts? Now, in the days when the immigration courts were functional, I mean, a case can take years to get decided today. You would bring this kind of case before a judge that your immigration lawyer, a nationality lawyer, knew was friendly to your type of case, and you would get the result you wanted. I can't give advice on that today. Maybe you can.
No. No. But I do find it interesting that that for all practical purposes, the State Department decides whether somebody, had 365 days of uninterrupted presence.
And if they've found that they made a mistake, they can revoke the passport.
Right. By the way, lest anybody get overly upset and overly nervous about the retroactive restoring of citizenship, and I think this is a particular issue in Canada because so many Americans came to Canada over the Vietnam conflict and became Canadian citizens in, say, the 70s. Basically, there's really no doubt in my mind but that those particular people intended to relinquish U.S. citizenship on the facts. I mean, it's hard to imagine any other argument that could be made because at that time, the information coming from the U.S. government was pretty clear. It's kind of like this, buddy, you become Canadian, you lose your U.S. citizenship, okay? No more complex than that. So on the issue of sort of retroactively restoring citizenship for the group of people who clearly became Canadian with the intention of relinquishing U.S. citizenship, it's very difficult to imagine any scenario for any reason that it could have been restored. I'm not sure I totally agree with you on the IRS thing. That said, it's okay. Okay, that's.
I'm just reading from their revenue ruling. I'm not agreeing with its legality.
I know what they say as well. But what I mean by that is this: that there's no evidence that the IRS, has sort of gone after anybody in this area particularly, right?
In fact,
so I mean, you have to raise your hand and call them up and say, listen. I was just wondering if you considered me to be a person who should be paying taxes to the U.S. government. Okay? Like that's actually what you would have to do. And we're talking a bunch of theory here, okay?
The IRS is not charged by either the Constitution or the law with determination of who is a U.S. citizenship and who is not. They have written a revenue ruling that is presumptively correct for some purposes.
Yeah, that basically presumes, okay, that somebody thought they lost their citizenship because they did commit an expatriating act that in most cases was later considered to be unconstitutional, believed they were not an American citizen, and then the issue arose later. Would that be a fair statement?
Yeah, but I could go on ad infinitum of cases in which presumptions and facts might be wrong, and the State Department, especially in case of older mothers, frequently asks for DNA tests to prove parentage on children born abroad.
On this particular topic, and if you have no comment on this, simply say that you have no comment. But one of the issues that's affected a lot of people in Canada has been the question of whether the new expatriation provisions of the Internal Revenue Code, specifically the exit tax, found in Section 877A, would apply to somebody who had lost U.S. citizenship, relinquished, say, in the 70s, okay, but did not bother to ever get a CLN, which nobody ever did.
Well, a CLN is evidence of a fact. It's hard to imagine that a CLN could be legitimately required of anyone who lost American citizenship when the CLNs weren't required and perhaps did not exist. So, but that's my view, and I'm happy to write it down in a letter, but I'm not an enforcer.
Well, that's the common sense view. You lost citizenship before the law took effect, right?
The trouble is that the U.S. government has made the world's banks and accountants the enforcers of its laws. And in fact, the British accountants professional association has gone further and said that a British accountant, at least this is how David Treitel puts it, that a British accountant has to see that his client has obeyed not only British tax law, but foreign tax laws as well. The result is, well, I'm not saying that every accountant does it, but...
Would that be an argument to not use British accountants, perhaps?
I mean, I think it would be an argument not to use a compliance condor, which you can define if you like.
Well, I don't have I know it's a pejorative term. I'm not sure what it is exactly. But yeah, I mean, I think that the general theme here seems to me that we have, because of FATCA and the IGA's foisted on the world, we have a situation where the banks are basically defining U.S. citizenship. I think in an incredibly narrow way, because all they're doing in many cases, they're saying, hey, you know, if you were born in the United States, you know, well, that's it.
U.S. personhood, which is you might want to define what a U.S. person is for the...
Yeah, so U.S. person is a term that has different meanings according to different statutes. In the Internal Revenue Code, a U.S. person would be a citizen or a resident, and resident would be further subdivided by either having a green card or meeting the substantial presence test. U.S. person can mean other things for different purposes. For example, in the Corrupt Foreign Practices Act, I mean, you know, U.S. citizens are subject to U.S. regulation and jurisdiction in a lot of areas that are not immediately apparent. Certainly, under the Corrupt Foreign Practices Act, it at least means citizen, possibly more. Interestingly, I heard a new definition of U.S. person, though, from none other than President Obama a couple of months ago on a YouTube video, where, I mean, clearly he, didn't understand in the technical sense, but he did talk about U.S. persons and then said, by those I mean who are U.S. residents, right? Which is clearly incorrect. But this is, I think, the root of this whole problem, that, when we talk about taxation, most people, live life with a perfectly reasonable assumption that people pay their taxes where they live. The United States is really the only country. I would not put Eritrea in the same category because well, it's frankly, it's such a more benign thing that Eritrea is doing, in the taxation area. But the United States is the only country that imposes both taxation and reporting requirements, right, on their citizens, wherever they may live in the world.
Well, the Philippines did until 1995.
And they had the good sense to get rid of it. Vietnam, I think, was another one. I mean, there have been a few. But actually, Russia seems to be moving in the area of identifying citizenship as a relevant criterion. You're all familiar with the FBAR, are you? The form, unfortunately. Well, basically, for those who don't, it's not in the Internal Revenue Code, it's in the Bank Secrecy Act. This is a gross oversimplification, so it doesn't even come close to legal advice, okay? But basically, you've got to report the highest balance in your Canadian bank accounts to, to U.S. financial crimes every year. I mean, it's really an extraordinary thing. Russia recently has adopted a foreign bank account reporting requirement. Now, what's interesting is that the U.S. one follows the requirement under the Internal Revenue Code, if you will, that if you're living abroad or whatever, you should be doing this. But Russia does not have citizenship-based taxation, but does have citizenship-based reporting of foreign bank account requirements. So this is, I would say, a major extension of the use of citizenship generally to get information about people and that sort of thing. The other thing that Russia has, that's very recent and very new, is a citizenship reporting requirement that is kind of similar to FBAR. In other words, if you're a dual citizen, if you have a citizen other than Russian citizenship, you actually have to register that citizenship with the Russian government. So these things are sort of citizenship is being raised and people's consciousness?
That's not unique. Switzerland, for example. And,
Same thing there?
Yes, but it's a benign thing. The only time it would be relevant is a Swiss child whose birth was not registered and had another citizenship at the age of 22. That child would lose Swiss citizenship if he or she didn't register at that point. But that's it's benign.
Yeah, perhaps for a different purpose.
The U.S. and Britain are two countries who do not know who its citizens are. Many European countries, specifically Holland and Switzerland, know who virtually all their citizens are because they're expected to register with a consulate office abroad or with the town council in their home place. Most Europeans, in fact, have to register their residence with the city hall. So it's a very unusual circumstance of the major Anglo-American countries, Canada, United States, Britain, Ireland, that you don't have to tell anybody where you come from or where you're going. Louisiana and Florida have voluntary provision for registering your domicile with the county clerk. But the only reason I would think that this was important was if you were trying to get out from under the tax burden of some other state. Mm-hmm. But I think Louisiana got it from the French, and Florida got it from all the old people coming from New York.
Do you think that might possibly be related to the fact that, well, at least the United States and Canada have born in the country citizenship? England does as well, doesn't it?
Not since 1983, unless the parent has permanent residence or certain other. And Ireland, by constitutional amendment, out of fear of immigration, of course, mm-hmm. And the political cynics raised the specter of immigrants coming from other continents just to have anchor babies.
Which is, of course, a big political issue in the United States. Mm-hmm. But on this issue of, again, a U.S. birthplace being sufficient to confer citizenship, I was actually in Bangkok, Thailand, the day the King of Thailand died. And, I immediately saw on one or more blogs, oh my God, he was born in the United States. I mean, his billions subject to the estate tax. So why would he not be a citizen?
Because he was a foreign sovereign.
Right.
And it is arguable. I don't know whether the protocol office of the State Department would answer the question that I asked them. But what was his father's status when he was born in Massachusetts? Sovereign immunity is something quite stronger than diplomatic immunity. You only have diplomatic immunity under the Vienna Convention. Sovereign immunity is something under international law. And basically, you have diplomatic immunity because you have been accepted by the receiving country. His father could have come on a diplomatic passport, but then the question is, did the State Department accord him immunity, or did he have the immunity anyway because he was a foreign sovereign? And that's something that's never been published.
Presumably, the story would be that he was having sovereign immunity. I mean, basically, no other interpretation is economically or logistically possible, I would think.
Well, the State Department doesn't publish private. There's a privacy rule. Boris Johnson is he almost certainly should have lost his citizenship if he didn't do it voluntarily, because he has taken up a policy-making appointment with his other government.
Provided that he intended to.
No.
He would have lost it anyway?
He has taken up a policy-making position, which that would be true of the King of Thailand, but as well, in fact, even if my theories as to sovereign immunity are wrong.
So, Andy, what's your thought on the problem of all these accidental Americans and the whole tax issue, and the banks identifying them and sending them these FATCA letters. And
well,
oh my
I'm
God.
not. I'm not going to advise anybody to break the law. I do caution people not to divulge potentially incriminating information to an accountant, except through a lawyer with a cover letter that would protect it from disclosure. There are so many issues, facts that enter into a decision. Nobody can obey all the laws all the time, and there are risks. If someone is, I have spoken, I talk occasionally to groups, usually of people who are fairly poor and facing this kind of issue and who couldn't possibly afford to become compliant. And the first question is, well, how old are you? You have people 80 years old and they're worried that the IRS is going to come. Bruce Zagaris has written an article, it's online, in a scholarly journal about the possibility of extradition for tax offenses. Now, there have been a few cases, but they've been things like value-added tax, carousel fraud, and major fraud cases. It's true the IRS is trying to equate tax evasion to money laundering and to common law fraud, things for which you could be extradited. But it hasn't happened except in these cases of criminal gangs. Certainly people shouldn't worry. And if they can afford to become compliant, that's a decision only they can make. But there are, in fact, questions to ask whether someone has income, assets, or heirs in the United States. But the first question is the question that you bring up each time. Were you, in fact, a citizen at all?
Right, or if you were, are you in a position where you can honestly claim that you performed a relinquishing act?
Sure. These are all issues, and to rush into a very, very expensive and soul-destructive procedure is terrible. And you in one of the previous discussions, brought up a case of someone who was not, in fact, a citizen, but got no refund for all the money that she paid.
Oh, far worse than that. 4 or 5 years ago, the IRS were running these offshore voluntary disclosure programs, and for the most part, those had petered out. But, I mean, it was a horrifying situation. I mean, it was basically for, Americans in Canada or Americans abroad in general. It involved the closest thing to bankruptcy I can imagine, because the penalties were very high, but the only way to get the penalties was to liquidate your assets that would generate more tax, etc. But what I found incredibly, just absolutely extraordinary about this is the number of people who were advised to enter these programs who clearly had lost American citizenship, years earlier, but were simply told by, tax professionals, whatever that may mean, that they were in fact subject to this stuff. So, I mean, there is absolutely no doubt that people need to be careful on the whole citizenship issue, because that is in fact, the triggering fact for the rest of it. I mean, if you're not a citizen, then, presumably you're not subject to this stuff, and if you are, then you've got to figure out how to deal with it.
If a court has not said that you were a citizen, the question is, can you be guilty of a crime if you honestly believe you weren't a citizen in the first place?
Well, certainly not on the willfulness penalty thing, because the definition of willfulness from the U.S. Supreme Court is very, very clear. I mean, it's the intentional disregard of a known legal duty, I mean, you have to know that there's an FBAR filing requirement, et cetera, to meet the willfulness. Okay, but that's, at the extreme end of what the penalties can be. There's plenty of things leading up to that and create problems.
I mean, it's long been said that tax systems are not there to do justice. They're there to raise revenue for sure, but more than that, they're there to execute political decisions. And that's the trouble that accidental Americans in particular have. No, they have no political clout, and nobody seems to care about them. And given the, I don't know, 200 almost IGAs and the effective threats to foreign banks to deprive them of the U.S. market if they don't comply and persecute people they think are American citizens. And then there are badges of citizenship, which are badges of U.S. personhood, that include such things as having a U.S. telephone number.
Yes, yes, yes.
I mean,
yeah, let's just amplify this a little bit, because this is, I think, an area of broad concern. So, basically, in 2010, a law known as FATCA was attached as an offset revenue provision to a broader piece of legislation called the Hire Act. The reason I emphasize that it was a revenue offset provision is because it was never, the broad intent of the legislation. It was just a way to sort of, provide a proxy for being able to pay for the thing. The bottom line is that very few politicians in the United States even knew about the law. The law basically was aimed at two groups. The first group was any non-U.S. financial institution, for example, the Toronto Dominion Bank, okay? The second group were Americans with what they would think of as being offshore assets, but it primarily affected the local bank accounts of Americans abroad. So on the issue of being aimed at individual Americans abroad, what it did is it extended statute of limitations. It sort of created new areas for penalties and basically ratcheted up the reporting requirements. The way it was aimed at the foreign banks was basically this. Either you enter into an agreement that you will identify every U.S. person who's your customer, and by the way, we get to define who a U.S. person is. In other words, it's completely subject to being changed on a year-to-year basis. If you do not enter into this agreement, then we will deduct 30% of all U.S. dollar payments going to your bank, right? If you can imagine how horrifying this would be. So what happened was that the banks, in their sort of terror of the situation, went to their governments and said, look, what you should do is enter into an agreement with the United States so that, basically we're not caught up in this, because the problem is this, from their point of view, leaving aside what they're really concerned is the 30% withholding, but how do they implement this without overriding, say, Canadian privacy laws that would say, you can't target people based on place of birth and stuff like that. So the result was what Andy describes, these agreements, these IGAs, where basically what happens is the banks agree to search for the information, turn the information over to, say, the Canada Revenue Agency, who then sends it on to the IRS. But the question is, what is it they're looking for? How does one hunt for a U.S. person? So they put together what you referred to as indicia, and these include place of birth, okay, as you point out, a U.S. telephone number, okay, believe it or not. I mean, think of it, right? You have one of these VoIP lines or something like that, standing instructions to, send money to another account, et cetera, et cetera. One of the things that I find interesting about it is, although this is aimed at U.S. persons, green card holders are not affected by this. Americans who are not born in the United States are really not affected by this. So what it's done is it's really turned it into, I think, just sort of a hunt for anybody born in the United States. And, if you're, and so what they're doing is they're sending out these letters both to individuals, which don't really turn up, I think, a lot of people. But they're also incredibly, this is truly mind-boggling. They're sending it out to entities. Now, by entity, I mean anything that's not an individual. It could be a trust, it could be a corporate brokerage account, or anything of that nature, and just saying, basically, okay, you have to answer questions, with respect to who are the beneficial owners of this thing, and are any of them U.S. persons. And of course, they can't even understand the question, without going out and getting, legal help. incredibly intrusive. I mean, it's absolutely mind-boggling. But this is the environment that this whole thing is taking place in.
And the penalties that often start at $10,000 for failing to fill out one of the forms for 3520 for trusts, 5471s for a foreign company, and the FBAR. It could more than bankrupt someone, and since you can't discharge these penalties in bankruptcy, it can throw you out of the money economy.
Oh yeah. Well, I mean, part of the problem is that, in my experience anyway, most people do want to comply with the laws that they, understand apply to them, but these rules are so complex they can't do it on their own. And when they start going out and getting advice from tax people, I mean, you can ask 2 different tax people and get like 10 different answers. So a lot of it, the only thing they understand is the penalty, right? I mean, nobody can read the Internal Revenue Code. It's completely incomprehensible except for one sentence. Failure to comply is a $10,000 penalty. That gets their attention, right?
We haven't even gotten to PFIC.
Oh my God, yeah, sure. PFIC, can you explain that? Well, it's a Buy America provision. It's a way to protect the American mutual fund industry from competition, is what it is.
Well, and it also picks up, except in those few countries that have exceptions for pension plans, it picks up your foreign pension. It picks up your state pension in Australia and your mandatory pension in Switzerland. And it essentially is double taxation. In any case, you are taxed now on the contributions, you're taxed on the accretions of the account, and then you're taxed in the other country when you take the money out.
Right, so in other words, 3 points of taxation. Okay, 1, at the point of contribution. 2, so you contribute to some investment vehicle, the return on the investment, and 3, the point that it's actually collapsed and, sort of the income stream comes through. And to that, though, these require specified forms that, I mean, they do not require 70 hours or whatever the IRS says. They simply do not. But they do require a lot of time. They're difficult to understand. And the overhead compliance cost to own these things makes it incredibly difficult for Americans abroad to both be U.S. tax compliant and be able to plan responsibly for retirement. And it's really the inability to, be able to securely plan for retirement that is driving the large number of peoples to renounce U.S. citizenship at this point. What else can they do? I mean, it's either they can remain a U.S. citizen and be impoverished, or they can renounce and have a chance at retirement.
There was a time, because some of my grandchildren got it, when the British government gave £250 to a trust account for any child born in the country. Well, that was very nice, except that you can imagine that most accountants charge more than £250 to fill out the paperwork. And it's every year.
Yeah, and well, you say every year, but one of the problems with this is that, so you want to be tax compliant, and most of U.S. taxation, I don't think has anything to do with taxation anymore. I think it has to do with information returns and supplying information. But the problem is that once you start filling out these forms, there's no way to ever stop, even if you're incorrectly filling them out in the first place, because how do you explain the absence of the form? So it's it's an incredibly difficult problem for people, and more and more people are just no longer able to deal with the anxiety, the expense, and all of these things that in combination I think really incapacitate them from any kind of retirement planning.
Well, they're either expatriating, or those who can't afford it are disappearing. Clearly, if the State Department is correct that there are 9 million American citizens abroad, I think it's maybe an exaggeration, but let's take a number reasonably close to that. You can look on the IRS website and get a number of tax returns filed, and it's under 1 million. So even if you take that some of them are joint returns and some of the 9 million are children, it's clear that there are millions of people who are not known.
No, there's no question about that. But it's not because they're deliberately non-compliant. Okay, I think that one of the things that one needs to remember here is that the vast majority of people, when they hear about this requirement, they actually go into a state of shock. I mean, they can hardly believe it because they've, lived their whole lives on the basis of they've been responsible citizens, they've tried to plan for retirement. I mean, the idea of their not being tax compliant anywhere is, it just creates, sort of a seizure of the brain, right? In the sense that, they can't even imagine it. And then they're, forced to deal with this problem. And if they're 50 plus, well integrated into, say, the Canadian retirement planning system or something like that, I mean, the compliance becomes, I think, almost impossible for them.
I'm reminded of the 10 years after Canada moved from estate taxation to capital gains tax at deemed sale on death, whereas the United States has kept its estate taxation, and it was at a fairly low exemption level at the time. For 10 years, families were double taxed on the estates of their American relatives. And it was a tragedy, but it took that long before a tax protocol was signed that resolved it.
Now, understand what that meant, though, in the context of double tax. And correct me if you think I don't have this right, please interrupt. But the U.S. estate tax is a percentage of the value of the asset, right? It's not based on a gain or something like that. So if you're having to pay both taxes, okay, let's just imagine that you have an asset worth $100. Okay, the way the Canadian thing was working was if you bought it for 50 and it was worth 100 when you died, that's a deemed sale, a capital gain of 50, and you'd pay tax on 25. But what's happening is that let's say we have a U.S. 40% capital gains
55.
tax. Sorry, 55.
That's the marginal rate.
Okay, 55.
There's a $5 million exemption.
Yeah,
well,
now there is, but there wasn't at that time, I'll tell you. Okay, I mean, in the 90s, it was as low as 500,000, but just to use that example. So $55 comes off the top on the U.S. estate tax, right? And then you're going to have another 25 or something like that coming off, on the Canadian thing. So is that 80? 80% gone, just like that.
And nobody cared.
Well, that's right. That's right. And I suspect a lot didn't know about it, so they didn't file. Oddly enough, the people who know about it are the people who try the hardest to be compliant. They hire expensive accountants and things like that. But it's a very, very difficult problem, and it seems to negatively affect most of the people who try the hardest, to actually be compliant. But most of them don't know about this anyway.
Well, people are learning now.
They're learning now.
And if you look at the statistics, you see that more and more parents are not registering the births of their babies abroad. They're looking ahead to things getting worse, but that doesn't change the fact that the child is an American citizenship.
Well, no, I think it's prudent to not register them. They can always do that themselves. Okay, there's no reason it's not like the child's losing anything. Whatever. I mean, there's no requirement that I'm aware of to.
There's no penalty.
Yeah, there's no requirement, no penalty.
But it's not. It isn't. In many cases, of the people I speak to, it's not even a fact of avoiding taxes at some time. It's anger that they simply don't want to give recognition to a government that is destroying their lives.
Well, that is the simple fact of the matter at the moment. I mean, things have changed incredibly. I mean, I've lived most of my life in Canada, and I've sort of survived almost all of my adult life in the U.S. tax system, as hard as it is, and it's very, very difficult. But because I've lived through this and seen the progression, I mean, I would agree. I mean, I think it is somewhere between difficult and impossible to live as a tax-compliant American outside the United States. And even on the difficult, which is the best-case scenario, it is incredibly expensive to do so. I mean, there's no doubt about that.
Well, there's a lot that TurboTax is an excellent software, but first, a lot of people can't use it, and secondly, it doesn't do a lot of things for overseas filers. And some of the things that it does do, you have to be an expert and go to the forums and see how you can override the
oh yeah, well that's just on the compliance area. But don't forget that if we look at just some very, very basic ways that people in Canada do retirement planning. Now, Is there anybody in this room who would disagree with the following? Canada is a very high tax country. Yeah, you know, it is, okay, no question about it. And, you know, one of the things that I think in compensation for that Canada has is a tax-free gain on the sale of the principal residence, right? Okay. And as you know, you're not going to get that as a U.S. Citizen, okay? You know, for small people, which is most people in the world, you know, they find mutual funds to be, you know, a good way of saving for retirement. And of course, the consensus is that those are taxed incredibly punitively under U.S. law. I mean, say you have something like Templeton Growth Fund or something like that, and you can buy it in Canada, you can buy it in the United States, and it operates the same way, it has exactly the same shares. The one that's bought in Canada will be taxed extraordinarily punitively. If you hold it for 20 plus years, the tax on the gains will reach 100%. Okay, you know, if you buy the U.S. version, and it holds the same shares, right? You know, it'll get sort of normal capital gains rates. A third area of many, you know, which is hugely problematic, is that, you know, many Canadian professionals, doctors, lawyers, and small business people, and this is true around the world, carry on business through these small business corporations, but these are considered to be foreign corporations under U.S. law. And if it's your corporation, it becomes a controlled foreign corporation, which basically means that the U.S. tax laws will attack the very purpose for which the thing is formed, right? So the simple reality of this is that for U.S. citizens in Canada to be U.S. tax compliant, they've basically made the decision to not be able to participate in a lot of the things that are really pretty essential, you know, for reasonable retirement planning in Canada. I mean, you're restricted to three things as far as I can tell. I mean, the first thing is individual shares, mutual funds, don't touch. The second would be rental real estate. Okay, you can buy a second house or something and rent it out. And the third would be, you know, basic interest devices. Okay, bank account. I mean, that's the most simple example. And that, you know, that really restricts your opportunities. Plus, it takes a lot more time, right? I mean, you just can't do the things that other people can automatically do and sleep at night.
You could buy gold, I suppose.
You can buy gold, yeah. You can buy gold. That's true. I don't think that's subject to FBAR reporting either.
No.
Is it? No. Okay. All the more reason to buy gold.
Well, then you have to worry about thieves, but that's another story.
What about the Form 8938? Is that a foreign financial asset for the purpose of that form?
I've seen arguments that it is, but
either way, I don't think it is. I don't know, but I don't think it is.
No, jewelry is certainly not.
No jewelry.
No, jewelry is fine. Yes.
No art. All right,
no.
You know, et cetera, et cetera. What do you want
foreign
to
life
add?
insurance, that's another one.
Yes. No American in Canada should have any kind of insurance policy whatsoever. Okay? Because of the first of all, it's life insurance. If it's anything other than term, okay, if it has any kind of investment component, you're going to have PFIC problems, right?
Yeah.
But there's a little known provision of the Internal Revenue Code. This is absolutely extraordinary, okay? I used to say, you can't make this up, but it's true. There's an excise tax, okay? If you buy a foreign casualty policy, you should be paying a small amount to the IRS every year for having bought that. I mean, it's not enforced, but it is on the books.
But there are worse things. At least with Canada, there is an exemption for interest tax, withholding tax on interest payments in the tax treaty. With India, there's no such. So if an Indian, who is a U.S. person, a citizen of India, buys a house in India and has a mortgage on that house, let's say it's a repayment mortgage to make it worse, the interest is subject to a 30% withholding tax to be paid to the IRS, and you know that the Indian bank is giving no credit for that. And then each payment of the principal of the mortgage is subject to capital gains tax on the transaction, the value.
Oh, and to add to that, it would have to be converted to U.S. dollars, right?
Yes.
Yeah. So actually, yeah, this is fascinating. On the area of real estate, okay, believe it or not, and I would never lie to you about something like that. Basically, all of these transactions they have to be done in US dollars, okay? So you can be in a situation where you could buy a house for $100,000, well, you couldn't do that anymore, $1 million, and then sell it for $1 million, and there'd be no capital gain in Canada.
With a 100% mortgage, let's say.
With 100% mortgage, okay? So I'll do the house and you can do the mortgage, okay? All right, because it's really two transactions. I mean, this is so over the top, you can't believe it. So the first thing is that you have to convert these numbers to US dollars, okay, to do the transaction. So you can actually be in a position where you could theoretically have a capital loss in Canada but a capital gain on your US tax return, right?
Exactly.
Okay, just because of a fluctuating exchange rate.
And for that purpose, the mortgage is ignored.
Right. Okay, that's exactly right. Okay. Now, on the issue of the mortgage, there's two transactions going on, right? Okay, there's actually also the discharge of the mortgage. But here's the problem, all right? That let's say you have a $100 million mortgage in Canada, you take it out at one exchange rate, okay, and you discharge it at a different exchange rate.
Constantly changing exchange rate.
Constantly changing, every 2 weeks, okay, every 2 weeks.
You have to calculate what your gain or loss is on that mortgage principal repayment. And if there's a loss, that's too bad.
Exactly, because it's personal use, right? But if there's a gain on the house, then
it's you've earned some money. And
that's right.
Now there is a workaround.
So which is turned into investment.
Yeah, just before you sell, if you can rent it out, and turn it into an investment, then, of course, you may lose, depending on the timing and a lot of other things, your $500,000 exemption. But let's say you might...
$250,000. You're talking about a married couple.
Oh, that's right, yeah.
Yeah. So actually, on the real estate, you're getting a $250,000 sort of on the house capital gain, right, per American. So if it's a married couple, you've got $500,000.
And if it's 4 people, finally the IRS did come around and say if it's 4 people, it's $250,000 for each person. So if you and your 2 children own the house together, that's 4 people. So the whole $1 million could be.
All right, now this is important, okay? Keep listening.
But the point is that if it was held for business at the time you sold it, I don't think there's any specific time, but a year is a fair assumption, then you can take the loss of the foreign exchange on the mortgage to offset a bit the gain on the property.
Okay. No, I mean, I do
there are baskets of investment, and they have to fit in the same basket. This is not something that a little old lady who hasn't been doing taxes all her life can be expected to do. So she's going to be paying $10,000.
Absolutely. It's extremely complicated to be an American citizen. In fact, I've often thought that airlines should have a special class, they can call it American class, okay, where what they'll do is they'll take the information from the flight and give you a printout of how much time was spent over which country and how much of your plane ticket went for this and that, and then give it to you at the end. What do you think? Good idea?
Well, yeah. Oh, by the way, it gets more complicated if you had a home office, but
that's right. There is no, in fact, would you say that life as an American abroad, you really need to have a full-time lawyer.
And a psychiatrist.
And a psychiatrist in the family. Okay, on that note, I think we'll maybe stop the taping. Andy, fantastic. So nice. Yeah.